2018 leadership structure is not at all in conformity with the constitution of Shiv Sena and thus does not provide a reliable outcome and or answer to the question which faction is the real political party and hence cannot be relied upon to determine the preliminary issue. Decision of the Paksha Pramukh is not synonymous with the will of the political party and thus if there is a rift in the leadership structure, the decision of the Paksha Pramukh cannot be taken as the will of the political party. When there is a vertical rift in the horizontal leadership hierarchy of the political party and both the factions within the said leadership structure emerged as a result claim to represent the will of the political party, it would not be appropriate to apply the test of which of the said faction decision carries the will and wish of the political party. In the case of Shiv Sena political party, will of the majority leaders in the 2018 leadership structure cannot be said to be synonymous with the will of the political party. In view of the findings recorded in the preceding paragraph, I hold that the 2018 leadership structure read with the SS Constitution does not provide any reliable answer to the question which faction is the real political party and consequently the 2018 leadership structure cannot be yardstick to determine which faction is the real political party. With regards to the legislative majority, I am not going to spend much time because that question is rather clear. In view of the above observations and findings, I hold as follows. Which faction is the real political party is discernible from legislative majority which existed when the rival factions emerged. Legislative majority which existed when the rival factions emerged can be discerned and or inferred from 1. The Shinde faction resolution dated 21st June 2022 and 23rd June 2022 available on record of the Legislature Secretariat and the admitted position which can be inferred from the initiation of petitions against 38 legislators of Shinde faction by the UBT faction. Shinde faction had an overwhelming majority of 37 out of 55 MLAs with the rival when the rival faction emerged. From my analysis, observations, conclusions and findings recorded in paragraph 82 to 144 herein above, I hold that Shinde faction was the real Shiv Sena political party when rival factions emerged on 21st June 2022. In view of my findings that the Shinde faction was the real political party when the rival faction emerged and that Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022, I further conclude that Shri Bharat Gogaole was validly appointed as the whip as that was the reflection of the will of the Shiv Sena political party as on 21st June 2023. Following are the final conclusions, which is again a summary. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? I will also read the final conclusion. Following are the final conclusions from the analysis, observations, conclusions, findings and rulings recorded from paragraph 82 to paragraph 158 herein above. I conclude as follows. Shinde faction was the real Shiv Sena political party when the rival factions emerged on 21st June 2022. Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022. Shri Bharat Gogaole was validly appointed as the whip of Shiv Sena political party on 21st June 2023. Shri Eknath Shinde was validly appointed as the leader of the Shiv Sena political party on 21st June 2023. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct. Petitioner has contended that the respondents are liable to be disqualified on various grounds. Both the petitioners and respondents' submission are recorded in section 2 herein above. The various grounds on which the petitioner based the plea for disqualification is dealt with, where the alleged conduct of the respondent is purportedly becoming totally incommunicado, attracts disqualification under paragraph 2(1)(a) of the 10th schedule. Whether the alleged conduct of the respondents in purportedly becoming totally incommunicado attracts disqualification under paragraph 2 subclause 1 subclause A of the 10th schedule. The first ground on which the petitioner sought disqualification of the respondents is that the respondents became incommunicado. The submission cannot be accepted and the respondents cannot be held to be disqualified on this ground for the following reasons. The ground is a mere allegation, and apart from mere assertion that the respondents have gone incommunicado, the petitioner has not put forth any evidence or material to substantiate it. For instance, the petitioner has not provided any material about who was sought to be contacted and by whom, when such an attempt was made, etc. A mere unsubstantiated statement that the legislators have gone incommunicado cannot even be a ground to attract disqualification under paragraph 2(1)(a) of the 10th schedule. When rival factions emerge in a political party, especially within the leadership, it is possible for both the factions to allege that the other faction has gone incommunicado. In such a circumstance, especially in the light of the law laid down by the apex court in Subhash Desai Supra, it would not be correct to hold any faction to have incurred disqualification for going incommunicado without first determining which of the faction is the real political party, reflecting the will of the political party. Also, having held that the Shinde faction was the real political party when the rival factions emerged, the submission of the petitioner that the respondents have gone incommunicado ceases to hold any meaning for the purpose of disqualification. On the 20th of June 2022, elections for the Legislative Council were held. In his cross-examination, Shri Sunil Prabhu, PW1, stated that all the MLAs were present for the same. In the face of this evidence, it would not be possible to accept that the legislators had gone incommunicado. Respondents have placed that they have been in touch with the UBT faction. They substantiated it by stating that Shri Milind Narwekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents on 21st June 2022 on the instructions of Shri Uddhav Thackeray. This fact was not denied by the petitioner, Shri Sunil Prabhu, when a suggestion was put to him in the cross-examination. In fact, the petitioner admitted that Shri Milind Narwekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents. Also, three of the witnesses for respondents have testified that Shri Milind Narwekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents. On 21st June 2022, on the instructions of Shri Uddhav Thackeray, the testimony stood the test of cross-examination and the petitioner could not establish otherwise. Thus, on this count alone, or this count also, it would not be possible to accept the legislators were incommunicado, Whether the deliberate absence of the respondent in the SSLP meetings purported to be held on 21st June 2022 attracts disqualification under paragraph 2(1)(a) of the 10th schedule.